Divorce law in India. Definition. Divorce is the process of terminating a marriage or marital union. Divorce usually entails the cancelling or reorganizing of the legal duties and responsibilities of marriage, thus dissolving the bonds of matrimony between a married couple under the rule of law of the particular country or state. Under the Hindu Marriage Act, 1955, both the husband and wife have been given a right to get their marriage dissolved by a decree of divorce on more than one ground specifically enumerated in Section 13. Section 28 of the Special Marriage Act, 1954 and Section 10A of the Divorce Act, 1869 provides for divorce by mutual consent. Conditions required under Section 13B of the Hindu Marriage Act. 1. Husband and wife have been living separately for a period of 1 year or more. 2. That they are unable to live together. 3. And that both husband and wife have mutually agreed that the marriage has totally collapsed. Hence marriage should be dissolved. Under these circumstances a divorce by mutual consent can be filed. There are different laws of divorce for different religion. Hindus, which include Sikh, Jain, Buddha, are governed by Hindu Marriage Act, 1955. Christians are governed by Indian Divorce Act 1869 and the Indian Christian Marriage Act, 1872. Muslims are governed by personal laws of divorce, the Dissolution of Marriage Act, 1939 and the Muslim Women Act, 1986. Similarly, Parsis are governed by the Parsi Marriage Contested divorce. A contested divorce is the most complicated of divorces because it involves spouses that can't come to an agreement on one or many issues of their divorce. Thus they end up in court, asking a judge to make these decisions for them. Grounds for divorce. 1. Cruelty. 2. Adultery. 3. Desertion. 4. Conversion. 5. Mental disorder. 6. Communicable disease. 7. Renunciation of the world. 8. Presumption of death. One. Cruelty. Cruelty may be physical or mental cruelty. According to the Hindu divorce laws in India, if one spouse has a reasonable apprehension in the mind that the other spouse's conduct is likely to be injurious or harmful, then there is sufficient ground for obtaining divorce due to cruelty by the spouse. Two. Adultery. In India, a man that commits adultery can be charged with a criminal offense. The wife may file for divorce as a civil remedy. If on the other hand, a wife commits adultery, she cannot be charged with a criminal offense, though the husband can seek prosecution of the adulterer male for adultery. Three. Desertion. One spouse deserting the other without reasonable cause is the reason for divorce. There should be proof for it. As per the Hindu laws, the desertion should have lasted at least 2 continuous years. 4. Conversion. Divorce can be sought by a spouse if the other spouse converts to another religion. This reason does not require any time to have passed before divorce can be filed. Five. Mental disorder. If the spouse is incapable of performing the normal duties required in marriage on account of mental illness, divorce can be sought. If the mental illness is to such an extent that the normal duties of married life cannot be performed. Six. Communicable disease. If the spouse suffers from a communicable disease, such as HIV/AIDS, or a virulent and incurable form of leprosy, the Hindu law in India say that the other party can obtain a divorce.
Seven. Renunciation of the world. If the spouse renounces his/her married life and opts for sannyasa, the aggrieved spouse may obtain a divorce. Eight. Presumption of death. If the spouse has not been heard of as being alive for a period of at least 7 years, by such individuals who ago would have heard about such spouse, if he or she were alive, then the spouse who is alive can obtain a judicial decree of divorce. Void marriages. Following are the grounds which shall render a marriage void or the court shall deem it to be illegal are, 1. Bigamy. None of the parties to the marriage shall have a spouse living in the time of their marriage. If either of them has a spouse alive from an earlier marriage, their subsequent marriage is no marriage in the eyes of law. It is void ab initio and non-existent. 2. Persons falling within the degree of prohibited relationships. 3. Sapindar relations, Hindu Marriage Act. The parties intending to dissolve marriage are required to wait for at least 1 year from the date of marriage. They have to show that they have been living separately for a period of 1 year or more before the presentation of the petition for divorce, and that during this period of separation they have not been able to live together as husband and wife. The divorce petition is filed in the city where both the parties lived together for the last time. Thank you.